I've said it before, and let me say it again. Federal Judge Aileen Cannon's corruption is matched, if not exceeded, by her utter incompetence. And every time she lodges one of these new paperless orders in the Mar-a-Lago criminal document case where Trump withheld national defense information, I am just in awe of not just the corrupt intent that Judge Aileen Cannon is clearly showing, but just the utter idiocracy on her docket. Let me show you the recent paperless order that was just lodged. And here's what she wrote. Paperless order clarifying CIPA Section 4 hearing for February 13th, 2024. Just pause there. What are you clarifying? CIPA Section 4 is very clear. It doesn't need clarification. CIPA Section 4 says that the government goes ex parte, in camera, with the federal judge, shows the federal judge documents that they want to withhold that are classified documents in the interest of national security. The government shows Judge Aileen Cannon or whoever the judge why they think these documents are not relevant and helpful and why there needs to be a substitution. The judge either rules the government's right or the judge rules the government's wrong and orders that the government turn over the documents to the criminal defendant. If the government disagrees, they get to appeal. It's like the very simple process here. This isn't rocket science. There's nothing complicated about it. There aren't circuit court splits. All of the courts agree right here about what CIPA states, what CIPA Section 3 is, what CIPA Section 4 is. So the very fact that she starts her paperless order, says paperless order clarifying CIPA Section 4 hearing. This is why does it need clarification? It should just be so super simple. Hold one hearing with the government, let them show you the classified material, rule whether or not you're going to order the government to turn it over to Donald Trump or not, like in any case, whether the government should turn it over to a criminal defendant or not, and then there could be an appeal. But see, Judge Aileen Cannon doesn't want to make the substantive order because she knows she may get kicked off the case for her corrupt ruling, so she just wants to issue these paperless orders, and that's why there's this need for clarification. All right, paperless order, clarifying CIPA Section 4 hearing for February 13, 2024. Starting at 10:30 a.m., the court will conduct a sealed hearing with special counsel and cleared counsel for defendants Nauta and De Oliveira. Cleared counsel shall be prepared to discuss the classified information produced in classified discovery in the context of the relevant and helpful standard and the mens rea, mental state, applicable to counts 33 to 37 and 39 to 42 of the superseding indictment. To present argument on the special counsel's request to withhold all of the information from defendants Nauta and De Oliveira pursuant to CIPA Section 4, and discuss specifics with respect to the current figures of materials produced in classified discovery, including whether any of that information overlaps with unclassified discovery and or merits clarification. The hearing will be held in a facility suitable for the discussion of classified information. Defendants Nauta and De Oliveira may not be present. Defendant Trump is not required to appear. Notice there she doesn't say that defendant Trump may not be present, just that he's not required. In other words, Trump could show up. And then it says, counsel for defendant Trump may attend. Final CIPA Section 4 ex parte session with the special counsel to follow the 10:30 a.m. session. Nothing in this order should be construed as altering the current ex parte nature of the special counsel's CIPA Section 4 filings signed by Judge Aileen M. Cannon. I mean, just reading that, it's a total utter mess. And you go, Ben, can you break this all down for us? I mean, I can, but it is a complete and utter mess because she already held yesterday on February 12th a CIPA Section 4 pre-hearing as well to determine whether or not Donald Trump's lawyers should get access to the CIPA Section 4 filings and attend the CIPA Section 4 hearing. These are like pre-hearings to a CIPA Section 4 hearing to determine if Trump's lawyers and the lawyers for Nauta and De Oliveira should attend the CIPA Section 4 hearing, which they're not allowed to attend because CIPA Section 4 says it's ex parte in camera, meaning just the government and just the federal judge. Like, what in the world is going on here?
This episode of Legal AF is brought to you by Manukora Honey. It's getting colder, and this miracle of nature just fell in my lap at the perfect time. Manukora is a rare super honey that is 100% natural and has some unique properties. Manukora is made from Manuka honey, a single origin honey that comes from New Zealand, where the bees only feed on the nectar of the Manuka tea tree, making honey that is pure, rich, and complex with a creamier texture that is on a completely different level from the normal honey you find at the supermarket. You can use it as you would any other honey, but what puts the super in Manuka honey is that it's super rich in antioxidants and prebiotics, 3 times more compared to regular honey. On top of that, it contains an antibacterial compound called MGO that can be found exclusively in Manuka honey. The bottom line is that these nutrients really support your optimal immune and digestive health, and it's delicious. This is just the perfect way to treat myself with something that's going to keep me strong through the colder months, and the perfect gift for the people I love to keep them sweet and healthy too. The MGO 850 Plus Manukora honey has this creamy caramel texture that melts in your mouth and is unlike anything I've ever tried. I can grab a spoonful out of a jar to put in my favorite beverage or squeeze some honey out on some toast or oatmeal. It's so delicious. Manukora is savory, delicious, and truly the best honey I've ever tried. If you head to manukora.com/legalaf, you can get $25 off their starter kit, which comes with the MGO 850 Plus Manukora honey, a free travel pack honey sticks, a free wooden spoon, and also a free guidebook. It's the perfect gift for a loved one, no matter the season. Now, I love the jar and squeeze bottle, but the extra pack of compostable honey sticks is a perfect energy boost for whenever you're on the go, like traveling or running errands or taking a run or at the gym. That's manukora.com/legalaf to get $25 off your starter kit. This is just the ultimate honey. Indulge and try some honey with superpowers from Manukora.
I mean, you go back and you look at this order that Judge Cannon made back on February 5th of 2024, where she set these CIPA pre-hearings. I mean, again, these types of hearings, they're not even like a real thing. Like, she just made them up. And here's what she said back on February 5th. So she goes, on February 5th, she goes, on February 12th and 13th, 2024, the court will conduct sealed ex parte hearings pursuant to Section 4 of the Classified Information Procedures Act, CIPA. These proceedings will be held in a facility suitable for discussions of the classified information contained within the parties' Section 4 submissions. Anticipated schedule for the hearing is set forth below. So she says Monday, February 12, 2024, from 9:30 a.m. to 2 p.m., the court will hear arguments from defense counsel for all of defendants outside the presence of the special counsel. Consistent with the protective orders entered on September 13, 2023, defendants Nauta and De Oliveira may not be present. Defense counsel shall be prepared to discuss their defenses, their theories of the case in detail, and how any classified information might be relevant or helpful to the defense. Defense counsel shall also be prepared to discuss defendants' motion for access to CIPA Section 4 filings and defendants' challenges to special counsel CIPA Section 4 motions. What are you challenging with the CIPA Section 4 motions? Why are you asking to attend CIPA Section 4 hearings? You're not allowed to be there, so why is there even argument? So Judge Cannon says that's going to take place from 9:30 to 2 p.m. on February 12th, and then from 3 p.m. to 5 p.m., the court's going to hear argument from the special counsel outside the presence of defendants or defense counsel. The special counsel shall be prepared to discuss CIPA Section 4 motions and follow-up items from the sealed ex parte hearing that was held on January 31st, because she held a pre-hearing. She held a pre-hearing before a pre-hearing, and then she held this pre-hearing on Monday, February 12, 2024, where she talks about that the defendants will show up, meaning Trump's lawyer, Waltine Nauta's lawyer, Carlos de Oliveira's lawyer, and Trump actually showed up. So you had a pre-hearing January 31st, then you had a pre-hearing Monday, February 12, 2024, and then she just held a pre-hearing. She wants to do a hearing now on February 13th with just the lawyers from Waltine Nauta and Carlos de Oliveira. Like, why in the world would they have any access to any CIPA materials whatsoever? I mean, Trump clearly shouldn't at all. Zero, period, full stop. But Trump's body man, the guy who gives Trump the Diet Cokes, Waltine Nauta, why in the world are you having a full day's worth of hearings so that Waltine Nauta, the person who moved the boxes around for Donald Trump, who's not supposed to be looking at these documents, why does this have anything to do with, as she says in her recent order, the mens rea, the mental state? Why does it have to do with the underlying documents, whether the whole point of CIPA Section 4, right, is there's nuclear codes, for example, if there is war plans, if there's highly sensitive types of information, the government can say, look, it's not relevant and helpful, the actual codes themselves, so we're going to withhold it. But what we can do is we'll substitute it. We'll put some other summary in place of the codes. This way you can get it, but the underlying codes and war plans and the material in the classified documents is not relevant or helpful to the mens rea, to the mental state involved for establishing intent or establishing the elements of a crime. Why? The issue is, were these documents national security information, as that term is defined by the criminal code? And were these documents willfully withheld, intentionally, maliciously, willfully withheld from the government? And when the government asked to turn it back, were there efforts to obstruct justice and to stop it? It's that simple. It's just that simple. So Cannon's held a pre-hearing, a pre-hearing. A pre-hearing is set for Tuesday, February 13th, 2024. And now that's what she's saying that she wants to hold in this minute order, which is taking place right now, to discuss the mens rea of Carlos de Oliveira and Waltine Nauta relative to these documents. And by the way, Trump showed up at that hearing yesterday, and Trump is permitted to show up to the hearing today. But here's the thing, too. There's a number of documents and things, in addition to protected by the CIPA protective order, there's a number of documents that could be what's called attorney's eyes only, that Donald Trump's not even allowed to, potentially know about. So if those types of documents are being discussed during these, kind of closed door hearings, I find it to be very, very odd that this is taking place. It's contrary to all of the law. This should be one basic minute order. Government, submit your CIPA Section 4 documents. We'll hold an ex parte in-camera hearing. You hold the hearing. If you have some follow-up questions, then you maybe go hold one other hearing with defense counsel and see if they have arguments why certain subsets may be relevant and useful, relevant and helpful. But you can't tell them, what the documents themselves are. You have to explain what their theories of the case are. Then judge make a ruling. And then if the government disagrees, they'll appeal. If they're fine with your ruling, the documents get turned over to Trump. What the heck in the world are you doing, Judge Aileen Cannon, here? I mean, it's like an incomprehensible, it's like an incomprehensible minute order. It's like a law student who didn't do the reading, who's trying to act smart with using big words or kind of confusing sentences. That's what Judge Aileen Cannon is doing right here. It's worse than that, quite frankly, but I wanted to bring you the up-to-date news on Judge Aileen Cannon's corruption and incompetence. Hit subscribe. Let's get to 3 million subscribers together, and have a great day.
Hey, Midas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.